because that it is normal that to affect the migration flows, because the migration as a phenomenon is part of the human life. Thank you so much. If you have some questions, we will ask after the presentations. Again, thank you so much. And I wish to have the fruitful cooperation in the future with all of our guests. Thank you.
Dear Professor, thank you for your presentation. Now I invite our third keynote speaker, Associate Professor Milena Galitin from University of Business Academy, Novi Sad, Serbia. She will present about digital childhood and children's online privacy. She will talk about the risk that children face to face on the internet, especially about privacy. Dear Professor, the floor is yours.
Okay, good morning, and my sincere congratulations to the organizers for a very interesting and well-organized conference. It's a great honor and privilege to be with you today in Kosovo and the International VİZYON University. Thank you for inviting me to the International Certificate Conference on Artificial Intelligence, Human Rights, Migration, Democracy, and Public Input, and special thanks to Professor Filipos. The conference topics are very carefully selected and very current. They are highly relevant to contemporary academic and societal development. So as a professor of international law and artificial intelligence, I truly appreciate this invitation and the opportunity to contribute to the conference. For this conference, I wrote an article, so it's a digital childhood, the European Court of Human Rights approach to children's online privacy, with my colleague, Professor Mariana Nadina. So I'm going to present our paper. So the key question of our research was that the European Convention on Human Rights, which is developed before the digital revolution, provides an adequate response. Shall I move it? Like this? If you say. Okay. So that's the European Convention on Human Rights, which is developed before the digital revolution, and provide an adequate response to contemporary challenges to children's privacy in the online world. So our presentation consists of the following parts. So it's introduction, methodological framework, key findings, limitations, and conclusions. So children today are digital natives. They are legal instruments designed to protect them were built for an analog world. So today, the digital childhood reality is online environments are central to children's educational, social, and recreational lives, and also profiling, monitoring, and commercial exploitation of children's data, their exposure to harmful content and cyberbullying, and vulnerability amplified by the giant choices of digital platforms. So concerning the legal framework in question, is that the European Convention of Human Rights is reference normative framework for 46 Council of Europe member states, and Article 8 of European Convention of Human Rights is that to respect for private and family life. And the convention was adopted in 1950, so in 3 days of the digital revolution. So the core research question was, is the framework still adequate for this time? So the study is based on doctrinal legal analysis. So it's a systematic analysis of European Court of Human Rights judgments addressing the intersection of privacy protection and digital environment, from foundational cases to the more recent case law. Article 8 of European Convention of Human Rights, so focus is on the forced interpretation of positive state of the obligation under Article 8 in the right to respect for private life, and how this has evolved in digital context. And the living instrument principle, so analysis of the evolutive interpretation between how the court uses the convention as a living instrument to adapt our 1950 text of the convention to challenges that have not been foreseen at the time of drafting. So, positive obligation between key findings, and we have a case which is cornerstone precedent, and here are the facts of it. So, unknown person posted a sexual advertisement on a dating site in the name of a 12-year-old boy, and the advertisement, of course, was false, and the child had no knowledge of it, and his accurate contents were included in the advertisement, and another friend contacted the child seeking to meet him. And Finnish law at that time said that malicious misrepresentation was insufficient to compel the service provider to disclose the person's identity. So, we have findings of European Court of Human Rights, and the court found that Finland violated Article 8 of the European Convention of Human Rights, and that there was a legislative gap, left the child without effective protection. The states must not only refrain from interference, they must take active steps to protect individuals from third-party intervention, and this includes obligations towards private actors such as digital service providers. So, key principle is that online anonymity cannot absolutely alter the protection of child's fundamental rights, particularly where threats to physical integrity individually are at stake. So, this is doctrine of positive obligation under Article 8 of the European Convention of Human Rights, requires states to take active measures to protect individuals from privacy violations committed by third parties, including private entities such as digital service providers. It has legislative dimension, which means the states must ensure their domestic law contains no gaps that leave children without effective protection in the online environment. Then operational dimension, which means that states must ensure practical mechanisms exist to identify and punish the perpetrators of online violations, including the capacity to fulfill service providers to disclose relevant information. And evolutive dimension that includes apply the living instrument principles to extend the convention protection to digital content, not complete contemplated in 1950, regarding positive obligation and adapting to technological changes. And during the research, we found two limitations. First is the active nature of judicial proceedings, which means that both after violation has been closed. So it can identify infraction fields but cannot prevent them. And the judicial remedies, even robust, are too late to undo the harm to a child. And the second limitation is jurisdictional limitation to the conventions, which means that as major platforms operate outside the Council of Europe area. So, in the conclusion, we could say that the European Court of Human Rights, through the doctrine of positive obligation and the interpretation of Article 8 of the European Convention of Human Rights, offers an important but insufficient response to the challenges of protecting children's privacy in digital age. So, what does the European Court of Human Rights framework provide? It provides binding positive obligation on all 46 Council of Europe member states, landmark precedents establishing children's online rights, and the instrument doctrine enabling adaptation to digital challenges. But it cannot provide alone, that is preventing protection, then direct reach law possibilities of outside conventional jurisdiction, and real-time regulatory responses to rapidly evolving digital times. And at the end, what is required component system, which means the example case from the legislative framework, then the national implementation which is the best interest as an activity, not implied principles, and integrated multi-layers approach across all stages of legislation. Thank you very much.
Thank you very much for your presentation and time management, dear Professor. Because we are finished with the first part of the session, now we move to the second part of the conference, answer and questions. Please address your question with the surname of our keynote speaker. Do you have any questions from students or from our colleagues? Professors?
Hello. I would like to thank first of all Professor Hassan for his presentation. My question goes to you. You said that you have analyzed the Devdipak research. Where was your focus? Did you analyze all of the articles or you choose a topic?
Journal AI policy. Devdipak is a platform.
Yeah.
There are many, approximately 2,500 journals, and some filter Scopus index, WOS index, and other index. I select Scopus indexing journal, 140 journals. Yes, and journals menus AI policy, AI publishing, AI using policy. Select totally 28 journals has AI policy, and 8 journals similar, copy paste, similar AI policy, and 20 journals AI policy original, and analyze, thematic analyze, and I find 9 dimension categorize ownership responsibility, permission, legal issue, restriction, and 9 dimension, and there is this dimension and analyze most of problem, restriction, limitation, and legal issues. After using an ethical problem, what is the our action, journal action? Permission declare and declaration and disclosure, no problem. All of journal similar and using no problem. But after using, is there any ethical problem? What is the act, editorial act? This main problem. And unclear. Ownership now clear. No ownership. Ownership now, but responsible, yes. Owner responsible. But some issues, this conference issues, human rights problems and restriction, legal and sanctions and ethical actions, unclear now, journal. This is the developing country, Turkey, developing country and journals, but developed countries, for example, Elsevier, most of journals are publishing house unclear now. So we must take action about the unethical using the AI publishing. What is the ethical action? This is the main problem now. This Congress focus problem.
Thank you very much for your answer. Do we have another question? Because we don't have other question, now we move to the certificate presentation session. Ibrahim Yusuf, the floor is yours.